recently left corporate America to start your own business. You received a letter from your former employer reminding you of your non-compete obligations, and now you have verified that your prior employment agreement does in fact contain a non-compete. What now? This is Jonathan Page. We have helped numerous entrepreneurs successfully navigate their post-employment restrictive covenants and then scale their new business fast and with confidence. Here are 3 options to help you successfully navigate your non-compete. Now, before we jump into the 3 options, let's quickly discuss the main components of a non-compete. A non-compete contains 4 main components. First is a restrictive period. This is the time period immediately following your termination or separation in which you must comply with your non-compete. 2 years is typical because most courts have consistently held that 2 years or less is valid and consistent with your employer's legitimate business reasons. The second is the prohibited activity. This is the activity that you are prohibited from engaging in for a competed business. For example, if you worked in operations at your former employer, then working in operations for a competitive business, even a business that you started, would be in violation of the prohibited activity. The third is the restricted territory. Now, this is absolutely critical. The restricted territory might be within a specific geographic radius of any location that your former employer had operations, for example, 12-mile radius, or it may be the entire United States, or it may be limited to specific states. But there is a specific territory in which you are prohibited from competing in. And then fourth is the definition of a competing business. Oftentimes this is broad. So it'll say any business that is in the same or similar business as your former employee. But sometimes it can be limited. So for example, we represented several executives that worked at a company that sold pre-employment screening tests. And when we negotiated the definition of a competing business, we limited it to competitors that sold pre-employment screening tests on a wholesale basis. So what did that mean for the executives? That meant that they could go work at companies post-employment that sold the pre-employment screening tests direct to consumer, like consumer reporting agencies. So this opened hundreds and thousands of companies that were technically within the same overall industry, but were not in the specific industry segment that their former employer operated in. So that's the fourth component of a non-compete. Now here are your options. Option 1, which involves the least amount of risk, would be simply to operate your business outside of the restricted territory. So if the restricted territory is Georgia, then operating your business outside, in any state other than Georgia. Option 2, which involves more risk, is to send your former employer a letter outlining your plans and asking for their acknowledgement. Now, we have done this successfully for many clients. Here's the situation. If you're going to scale big, then your former employer is going to find out about your plans. By sending a letter, especially a letter that is written by an attorney, this will help draw the employer out and allow you to gauge what your former employer's reaction will be when they find out about your plans. Instead of wondering, right? You don't tell your former employer, you go do it, and then you get a cease and desist letter, and now you're in negotiations anyways. So this is kind of a preemptive measure that you can take that says, hey, I'm gonna I'm gonna operate my business that's technically gonna be in violation of my non-compete. Why don't I just draw them out now, and then we'll start negotiating. This can result in negotiation. In rare situations, it actually results in litigation. So there's some risk to this because you're letting your employer know what your plans are. But once you've gauged their reaction, then you can sit down with your attorney and determine the next best steps. And then the third option, which involves the most risk, is to go ahead and operate your business as you plan to operate your business, but just do it by mitigating the risk of operating your business in the gray areas. So what do I mean by that? Well, for example, if the restricted territory is the entire United States, but because you worked for your former employer, they really only have material operations in Georgia, Florida, and Tennessee, then operate in Alabama. Yes, you're in technical violation of your non-compete, but you've built up a defensible position. Now, we don't often recommend that you go with option 3 because, again, it involves the most risk and it could end up in litigation, and nobody wants to be in litigation. But that is an option. So these are your 3 options for helping navigate your non-compete. If you have any questions or you need any help, feel free to reach out to us. We would love to look at your employment agreement, sit down with you, and discuss various options for you so that you can move forward, scale big, scale fast, and scale with confidence. Jonathan Page with N Prime Legal. Talk to you soon.